Greetings, everyone. I am Oyufu, and it is with great honor to sit here and speak before the Parliamentary Working Group on Land Reform. And now I'm going to start my presentation. Just imagine that you are trying to sell your house or land, and it may seem like the final step, the end of your ownership journey. But what's behind that ownership can be quite complicated. There might be hidden interests, informal promises, or even unclear rights in the background. And these issues may seem small, but they still matters a lot in land ownership. While judges have tried their best just to explain these problems, because this isn't just legal detail, it's about fairness and trust in land ownership in England and Wales. In the past, before 1925, people proved land ownership with old paper documents, which these papers were fragile, easy to lose, and could be destroyed or even fake. Besides that, disputes depended on old memories or family stories back then. So, to fix this, the parliament made reforms in 1925 and later created the Land Registration Act 2002, which is also known as the LRA 2002. This act, I mean, this law aimed to build a modern and reliable system. And today, about 90% of land is registered. And yeah, that's a great success. But there's still 10% of land not registered yet. And these pieces of land are usually old or inherited, and they can still cause problems like confusion, fraud, or delays when people want to sell them. Our land registration system is built on three connected principles: the mirror principle, the curtain principle, and lastly, the insurance principle. And now let's start with the mirror principle, which is the most important and the main focus today. This principle says that the land register should clearly show all legally relevant information, including ownership, rights or interests, and restrictions, just like a mirror shows a clear reflection. This principle is supported by Section 27 and 58 of the Land Registration Act 2002. Section 27 says that important dealings with land, such as leases longer than 7 years, or sales and mortgages, must be registered to be legally effective. While in Section 58, it says that once someone is registered as the owner, the law treats them as the true legal owner, even if prior defects existed in the chain of title. This helps to clean the title so that buyers can trust what they see on the register and don't need to check all the old documents or deeds. In theory, this gives certainty. What you see is what you get. The second principle is the curtain principle. The curtain principle means that some rights, especially equitable or beneficial interests like family members' rights under a trust, stay hidden behind the curtain. The buyers don't need to worry about these hidden rights if they follow the correct process. If the buyer pays the purchase money to two or more trustees, these hidden rights are removed from the land and attached to the sale money instead. This process is called overreaching, and it protects buyers from complicated family arrangements. Lastly, the third principle, insurance principle. The insurance principle acts as a safety net in case the register is wrong. It is found in Schedule 8 of the Land Registration Act 2002. If someone loses money because of a mistake of the in the register, for example, due to fraud or a registration error, the state will usually pay compensation. A good example is the case of Swift First Ltd against Chief Land Registrar, where the lender was paid compensation after a forged mortgage was removed. So, in summary, these three principles work together to support the land registration system. The mirror principle gives certainty and helps people see who owns what. The curtain principle keeps complex equitable rights off the register to make buying a land easier. And lastly, the insurance principle gives confidence, offering a backup when things goes wrong. But is the system perfect? In my opinion, the mirror principle especially has problems. The biggest problem is something called overriding interest. These are rights that affect the buyer, even though they are not shown on the register. One common type is the right of someone who is in actual occupation of the land, and this is written in Schedule 3 of the LRA 2002. Besides that, the LRA also protects legal leases under 7 years and certain easements. But the rule about actual occupation is the most debated. It allows hidden rights to affect buyers, even though those rights are not on the register. And yeah, this goes against the mirror principle. But the law doesn't clearly say what actual occupation means. There's no clear definition for actual occupation. So the courts needs to decide it case by case, looking at things like whether the person is living there, how long, and if their presence is obvious or not. And yeah, this makes it hard to come up with decisions. In Williams and Glynn's Bank against Boland, the court held that Mrs. Boland, who was living in the property and had made financial contributions, had an overriding interest even though her right wasn't on the register. Similarly, in Chokar against Chokar, Mrs. Chokar retained her overriding interest despite being temporarily away in hospital to give birth because her belongings were still there and she intended to return to her house. Besides that, even commercial parties are not spared. In Kingsnorth Finance Co. Ltd against TZ, Mr. TZ's wife had an unregistered beneficial interest and was regularly staying at the property. The court found she was in actual occupation and Kingsnorth's failure to properly inspect the property cost them. All three cases shows how fragile the mirror is in practice. There are also some practical problems. First, like I mentioned just now, it's hard to define or prove actual occupation. Second, buyers often need to visit the land and inspect it themselves, which makes the register less useful. Third, 10% of land is still unregistered, like I showed at the slide 2. So the mirror principle doesn't apply. And finally, many people don't know how to protect their rights, especially vulnerable or small property owners. So, while the, while the mirror principle says the register should show everything in real life, actually it doesn't. Per Lord Wilberforce said this sentence: "The register is not a substitute for conveyancing." This means buyers still need to investigate the property beyond what is written in the register. That's a strong statement and it shows why trust in the system is weakening. If the register doesn't show all rights, then what is it really worth? So, because of all of this, I believe that reform is needed. First, the parliament should give a clear legal meaning to actual occupation. There needs to be a clear definition of actual occupation, and this can include things like physical presence, having furniture or belongings at the property or land, or even controlling the property or land. That would make the law easier to apply and reduce uncertainty. Well, since the law is currently decided by case, this change would help judges, lawyers, and buyers to understand what counts as occupation. Secondly, we should reduce the types of overriding interest. While the overriding interest for me seems to be a dual-edged sword. On one hand, they protect vulnerable people who may not have the knowledge or means to register their interests. On the other hand, they make the register less reliable and less certainty. As Jaap Zevenbergen wrote in 2024, a mirror should not show invisible things. To balance fairness and transparency, the law should limit these interests. For example, by removing certain easements or restricting the protection of actual occupation to very clear situations and leaving only a few basic rights like short leases or public paths should override the register. Thirdly, we can add a simple disclosure form in every sale of land. Sellers would declare any unregistered rights they know of, and this would be easy, cheap, and helpful to buyers. It would also help reduce the effect of overriding interest because it gives more visibility to off register interest during the transaction. Fourth, we should complete universal land registration. Well, around 10% of land in England and Wales is still unregistered, which means there is no register to rely on. This clearly weakens the mirror principle, and yeah, making compulsory land registration would make sure that every piece of land in England and Wales has a clear and central record, and this would increase legal certainty and reduce reliance on old titles deeds. Fifth, we need to improve public legal education. People need to know their rights and how to protect them. If landowners don't understand how land registration works, they may fail to register their rights, which leads to more unregistered land and weaker legal protection. Legal awareness also supports better use of electronic systems because people will be more confident in using them in this era. As Ryan Omar wrote in 2024, a mirror that reflects both seen and unseen things is no mirror at all. So, in conclusion, the mirror principle is still an important part. It's important of land registration. It helps confirm certainty in the system. But today, it is being weakened by overriding interest, unclear occupation rules, unregistered land, and outdated processes. The curtain and insurance principles do help, but they are not enough. Through reforms such as legal clarity, limiting hidden rights, universal registration, and even public education, the land register can become clearer, fairer, and more trustworthy. The mirror principle can then reflect not just legal ownership, but also the values of fairness. That's all from me. Thank you very much.